Because I want to start sleeping at night. I don't want to be like laying up.
2 years
Do I have
after.
a claim? Oh my God. Did I mention that copyright discussion? Oh my God. They might come after me.
This episode is powered by STG Corporate and Commercial Law. So imagine selling your company for 25 million US dollars. And then after 6 months, you get a claim of 50 million US dollars because the buyer thought, well, this is not the company that we agreed upon. And maybe you're buying a profitable company for 10 million US dollars just to realize that there was no necessary inventory, and now you have to put in 4 more millions the first 12 months.
Ouch.
Just to avoid bankruptcy.
Ouch.
And then also, the worst part, selling a company, you sign the agreements on $200 million, and then the buyer walks away because he thinks and claims that, well, a material adverse effect happened to the company, so he does not have to buy the company anymore. Mm-hmm. And these things do actually happen.
They sure do.
In M&A deals, and that's why we're going to have this M&A must-know series with our seasoned sharp business lawyer, Kat, who's going to take us through the key terms we must know so we know who walks away with what and why.
Yeah. So you might think that M&A deal terms is just that formal long share purchase agreement, right?
Yes.
But like your examples show, it's not. It's so much more. It's so reality. So regardless if you're an entrepreneur looking to sell your company or you want to work in finance, work in M&A, the deal terms and how they actually hit the deal, what incredible consequences they can have, is immensely important.
Yes, we're going to take you through the market practices, what is negotiable, and what you must have in your deals, because believe me, it's a lot.
It is.
So what are we going to talk about today?
Reps and warranties. That
Sounds
is
interesting.
Well, it's the seller's nightmare.
Yeah.
Yeah. You don't want them as a seller. As a buyer, you want them to be 45 pages long.
So where do we start with this big subject?
Yeah. So if we have that timeline that we always use, right?
Yeah.
So we started with the term sheet, non-binding. We had the due diligence, which is when the buyer investigates the company, right?
Yep.
And then we have signing.
Yep.
Signed a written agreement. That is where the reps and warranties come in.
Yeah.
And then we have closing. That is when the buyer actually gains access to the company. I get my money or my entitlement to the money, depending on how we regulate that.
Yes.
And then here, this is buyer. Here is when the buyer owns the company.
Yeah.
So up until here, seller owned. Here, buyer owned, right? Can do a color effect. So all of this, seller, buyer, right?
Yep.
Closing is where we shift hands. So, due diligence. You review the company because you buy, the bottom line is that you buy a company on an as-is basis.
Okay.
That means it might not be perfect. So it's on your buyer beware, right? Mm-hmm. It's on your end to investigate it and find out any problems. But you're not happy with that. That's not enough for you.
I want to know more.
Yeah. So in the agreement, you will demand that me as the seller, that I provide you with reps and warranties.
Yes.
That's promises. Statements of fact. I tell you that same as has been fairly disclosed, that is what you have been told or been able to review in the due diligence. There are no litigations ongoing. We own all of our IP. We paid all of our taxes. All of the employees have proper employment agreements in place. There are no other outstanding shares, save as the ones accounted for. We own and control the company and have the capacity to sell it, etc. So, statements of fact that I promise you that same as you should have been able to discover by yourself, and this is a negotiation part, how you define the reps and warranties. I want them to be as loose as possible.
But I?
You want them to be absolute.
Absolute, yeah.
There are no litigations.
Nothing at all.
No, that's my risk, if there are. If I say same has been fairly disclosed, and to the best of the seller's knowledge, there are no litigations, then I'm more protected, right? Then it could be a litigation, but I have not breached my warranty because I didn't know, right?
Yeah.
Or it was disclosed if you had just looked closer at the DD material in the data room. So that's a really important negotiation point for you to really dig deep into what is fairly disclosed. Is it only the material in the data room?
Yes.
Is it verbal communication, other written communication? Is it only with you? Is it with your legal advisors as well, etc.? Right?
So depending on how it's written, it's my fault.
It's your responsibility, your risk. Yes.
Damn.
Yeah. So it's super sensitive. I mean, this is incredibly sensitive. Because remember, a big company, no company is perfect.
No.
No company is perfect. From GDPR to disputes with lawyers to commercial agreements that have not been updated properly, etc. Right? So there's always something, right? So it's super important. The reps and warranties, my statements of fact to you that they are correct. And if once you have taken over the company, you find that the reps and warranties, that said, I own all of the IP that I've listed. There are no IP infringements. And then when you take over the company, somebody comes knocking at your door saying, that's my copyright.
No.
Then you can go back and point at the warranty and say, you know what? I'm suffering a loss now of 500K. But that is your warranty. There's a breach of warranty here. Give me the money. Then I have to pay. Right?
That's why this is so important.
Yeah. But if it was designed in a way where I can say, no way, that was fairly disclosed in the data room, then I'm not liable. Then I don't have to pay you. So incredibly important with the reps and warranties.
Yes, I definitely understand that now.
Yeah. And when we talk about the negotiated deal terms, you should know that the reps and warranties, they might seem like, whoa, I thought I was going to celebrate with my money. Do I just have to keep it beside me in the couch for 5 years because I might get a warrant claim against me, right?
Exactly.
So you will have caps. So it will be reasonable because still, you're buying on an as-is basis. You had the chance to investigate the company. So you put caps on it.
Okay.
So you talk about commercial warranties. That's like commercial agreements, employment relationships, copyright, the bulk. Typically, you'd say that's 20 to 30% of the total share purchase price. So if I buy a company, you buy my company for 100, I'm not liable up to 100. I'm liable up to 20, 30 million. Max, tops, that's it.
Wow.
So that decreases the seller risk. You want to have the caps as low as possible. You, of course, as the buyer, want them high. Yeah. But typical deal terms, say 20, 30%. And then also there are fundamental warranties. Those are that I really own the shares, that the company is incorporated properly. So those are so fundamental that if something's wrong, you basically don't have the company. So in such cases, the cap will be up to 100% of the share purchase price.
Okay.
And that's rather fair, right?
Yeah.
Because if I didn't have the capacity to sell the company, it wasn't duly incorporated, then you bought nothing or not at all what you thought, and that should probably be on the seller, right? If you can prove it, right?
Yes.
Yeah.
Wow.
And then we have tax warranties.
Of course.
Of course. And all of these tax warranties are typically also 20 to 30% capped. But all of these are also capped in time. Because I want to start sleeping at night. I don't want to be like laying up.
2 years
I have
after.
a claim. Oh my God. Did I mention that copyright discussion? Oh my God. They might come after me. I mean, it's nasty. So you have a limited time also.
Okay, that's really good to know.
Yeah. So the commercial warranties, you should accept 12 to 24 months. Like 1 calendar year at least. But not more. Say stop. That's it. If the buyer hasn't found anything, it's over. It's at the buyer's risk. But in relation to fundamental warranties, they will always be much longer. And tax warranties are typically depending on the statutory time, so 5 to 7 years.
Yeah, okay.
When the tax authorities can come after you, you kind of feel that if I screwed up with the taxes, it's on me, even if it's 5 years later.
Okay.
Yeah, that's it.
Wow, you really skipped the fluff here.
Yeah.
Tell us exactly how it is. And that's why you need to subscribe to this channel, because you only hear it here.
Yeah. And as a seller, you will also want baskets and tipping baskets. And that is that if there are tiny de minimis, then the buyer cannot come after you.
Okay.
Like any little. But if there are many, let's say that you have cars, you licensed cars. And I promise you that there are no insurance issues, that they're all perfectly in perfect shape, etc. One car that costs thousands of US dollars to repair has an injury or something. Nothing. But what if there are 200 cars with that tiny damage?
Yes.
So you'll have one de minimis for a single demand that it needs to be qualified, because you can't come running after me for everything when we're talking about the deal in the hundreds of millions, right? But also if there are several tiny issues, breaches of warranties, then if you put them all together in a basket, they qualify because they're over a certain amount.
Okay.
Then you can still come after me.
Okay.
Yeah. So that's it.
Really good
Done
to
for
know.
today. Yeah.
Done for today.
Yeah.
Thank you so much. Until next time.
Bye-bye.
Hej då. This episode is powered by STG Corporate and Commercial Law, a boutique law firm for you to call when you need direct and personal legal support.